Hey everyone, Russell Farbiarz from Antanavage Farbiarz. I wanted to answer another common question that we get is, well, what happens if I die without a will? Does that mean everything goes to the Commonwealth? And the answer to that is no. The Commonwealth is what we call the taker of last resort, but that would only occur if there are absolutely no heirs. So if someone dies without a will, the the term that we use is that they have died intestate. So that means died without a will. There are certain laws and rules that have been adopted by the Commonwealth to address this circumstance that say how assets would be distributed and then who would have the ability to serve as what's called the administrator, which is the same as an executor. They would have the same responsibilities to gather the assets, pay bills and taxes, and make distribution. So what happens if if someone dies intestate? Well, the first question that needs to be answered is, did they have a surviving spouse? Because if the decedent is survived by a spouse and nobody else, no parents, no children, then the spouse would receive the estate. If the decedent is survived by his spouse and one or both of his parents, then the surviving spouse would get the first $30,000 of the estate plus one half of the remaining estate, and then the balance, or the other one half of the estate, would go to the decedent's parents. Now, if the decedent was survived by a spouse and surviving children, they're also the children of that spouse, then the spouse would receive that $30,000, or that first $30,000, one half of the estate. However, if the decedent was survived by his spouse and children, but they were not children of the current spouse, the surviving spouse does not get that $30,000. They would only get one half of the estate, and then the balance of the estate would be divided between the children. If there is no surviving spouse, then the order of distribution would be first to children of the decedent, then to parents if they're living. Then if there are no children and no parents, then to brothers, sisters, or their children, so nieces or nephews. If there are no siblings that survive the decedent and no nieces or nephews, then the decedent's grandparents would be next in line. Then after that would be uncles, aunts, their children and grandchildren. And then if none of these people survive, there are no children, no parents, no siblings, no grandparents, no uncles, aunts, cousins, great cousins, grand cousins, whatever you want to call it. In that situation, then the Commonwealth would be the taker of last resort in that situation. As you can see there, by dying without a will, you often don't have control. Well, you don't have control over who will inherit, because you are bound by these state rules, and these rules may or may not be what you would have chosen for yourself, and can also have some unforeseen circumstances, such as increased inheritance tax being assessed, particularly if you would otherwise have left everything to your spouse, resulting in a 0% tax rate, versus now half of an estate potentially going to children or parents, which would result in a 4.5% tax being imposed on that portion of the estate. So it's very critical that you consult with an attorney to make sure that your estate is up to date. All right, thank you again, and we'll see you next time.